the point in our agenda where we hear from the public. And so we have one person who's signed up to speak, and that's Charles Langley from Public Watchdog. So 3 minutes, Mr. Langley.
Thank you. May I submit this to the
Sure. Do you mind giving it to our executive director so it can be read into the record? And then...
Oh, thank you. It's a table showing what the settlement for San Onofre is going to cost the ratepayers. My name is Charles Langley. I'm a public advocate with Public Watchdogs. Thomas Jefferson said governments have only one choice. They can be cruel masters or terrible servants. Today, the Commission is forced to make that choice in the case of songs. In this case, Southern California Edison chose to install untested experimental steam generators without the proper regulatory approval under CFR 5059. This reckless deployment of untested and unproven steam generators endangered millions of lives when a vital cooling component of the nuclear reactor failed, releasing deadly radioactive steam into the environment. How deadly, we'll never know, because Edison failed to report the leak publicly until 17 days later, when the radiation had dissipated. Make no mistake, Edison violated federal law when it installed an experimental nuclear steam generator without a proper federal design review. This is a classic example of a utility violating the prudent management standard. So now, instead of used and useful utility equipment, we have unused and useless equipment that the public is being compelled to pay for under this settlement. Sure, the settlement claims to return $775 million to ratepayers, but the total cost of the failure is $5.5 billion, and 40% of that cost is being borne by the public. The first step in these hearings should have been that Phase 3 would have been deployed first. Did Edison act recklessly in deploying these generators? And did they adhere to the prudent management standard? The evidence shows neither. We know the equipment is unusable and useless. And we know that Edison recklessly violated the prudent management standard when it failed to undergo a design review by the NRC for its defective and experimental steam generators. So what will it be? Cruel masters or terrible servants? If you approve this multi-billion-dollar bailout at ratepayer expense, you are funding the activities of Edison, our cruel master, and in doing so, you fulfill the role of terrible servant. But there is a third choice you can make. You can become a good shepherd and vote against this horrific settlement and order new public hearings. The public has a right to know how its rates are being set in public. Thank you.
Thank you. First item on the regular agenda is the settlement agreement on cost recovery issues associated with the San Onofre nuclear generating station. It actually is a proposed decision in the order instituting investigation into rates, operations, practices, services, and facilities of Edison's San Onofre natural gas facility. This facility is actually jointly owned with Edison and San Diego Gas and Electric and the city of Riverside's public utility. So this proceeding addresses the premature closure of San Onofre generating station unit 2 and 3, commonly referred to in our acronym as SONG, and determination of those who bear the costs resulting from the premature closure of the San Onofre nuclear generating station. The proposed decision adopts a settlement that's submitted by the parties and with modifications. If the decision is adopted and the parties agree to it in the subsequent filing, the modified settlement would go into effect immediately. So again, before I address the terms and merits of this proposed decision, I'm going to provide a little context. The Unit 2 steam generators were replaced in January 2001, and Unit 3 steam generators were replaced in January 2011. Both units have been offline since January 2012, which led us to open this proceeding, which actually began in October 2012. I'll just point out that the San Onofre nuclear generating station is located just off of the San Onofre beach, which of course is named for Onofreus, a desert hermit who likely lived in the 4th or 5th century and was celebrated for a simple way of life with little or no possessions. The nuclear power plant, however, was celebrated for providing about 2,340 megawatts of nuclear power when it was operational. Until the replacement steam generators began to fail, units 2 and 3 have been critical for providing reliable and carbon-free electric service to California for nearly 30 years. The closure of San Onofre nuclear generating station coincided with the closure of numerous large once-through cooling power stations in the coastal region of Southern California, which meant that this portion of California dealt with a double loss of generation at the same time. So the Commission and in fact the entire state of California dealt with the grid consequences of the closure of San Onofre and other proceedings. But in this proceeding, we focused on who should be responsible for the remaining costs of the station and replacement steam generators. In November 2014, we again adopted a settlement resolving this proceeding. However, subsequent to that decision, ex parte communications pertaining to this decision was closed, and these unreported ex parte communications should not have occurred and understandably hurt the public's trust in the work of the Commission. So we subsequently adopted a definitive response to the unreported ex parte communications and fined Southern California Edison $16.7 million for those actions. Since the unreported ex parte occurred, the legislature has adopted more comprehensive and rigid ex parte rules. In addition, 3 of the 5 commissioners who will be acting today were not members of the commission when the initial decision was adopted. So this reflects in part that this proceeding's been open for almost 6 years now. I think 3 different commissioners and 4 different judges. So in addition to finding SE, the Commission reopened their record to revisit the cost allocation issues resolved in the initial decision given the unreported ex parte communications. Parties to the proceeding offered many proposals and briefings, despite the fact that there was significant difference between the litigation positions of the party of the ALJ and assigned commissioners directed parties to attempt to reach settlement. And a settlement was eventually submitted to the Commission in January of this year. When the Commission evaluates a settlement, it does so consistent with Rule 12 of the Commission rules. The Commission may only adopt a settlement that is in the public interest, supported by the record and consistent with the law. So, with that in mind, I turn to that which is before us, which is the proposed settlement. This proposed decision adopts most, but not all, of the terms of the proposed settlement submitted by the parties. The history of the proceeding is complex. Key terms of the proposed decision are pretty straightforward. The utilities cease collection of all rates authorized under the 2014 settlement agreement as of a specific date, which is referred to in the document as the cessation date. The cessation date is the date on which the combined remaining balance of the SONG's regulatory assets of the utilities equals $775 million, excluding taxes. This date is estimated to be December 19th, 2017, if the Commission adopts the proposed decision in the error case, and if not, the date's April 21st, 2018. The utilities forego collection of the remaining balance on the San Onofre nuclear generating station's regulatory assets when that balance equals $775 million. The utilities will keep the amount already collected, but will not be able to continue to collect SONG's rates and costing rates. And after the utilities cease collecting rates, customers will not pay in rates any amounts for financing the San Onofre nuclear generating station regulatory assets. If the utilities, they'll retain all the proceeds from the sale of nuclear fuel investment, and there will be no additional credits from the sale of investment. So this is a marked improvement from the 2014 decision. If in fact the total amount reaches $775 million, which is somewhat on the sale of nuclear fuels, it decreases the amount ratepayers pay for the San Onofre nuclear generating station by roughly 16%. And depending, again, on the value of the nuclear fuel investments, the sum could be compared to that $775 million, but certainly between $500 million and $1 billion, and it ceases the collection of rates on a forward-looking basis. I note that this is somewhat similar, or at least closer outcome to that which was proposed by the Alliance for Nuclear Responsibility back in spring 2018 in a letter to then Speaker Renda, which is part of the record in this proposed decision. So, having said that, that's the guts and the real value to consumers. The proposed decision had two other items added that weren't really part of the recovery for ratepayers. It provided provision where SE shareholders would fund a greenhouse gas research program at Cal State University. The initial settlement had a different settlement, and that was imposed by the Commission after this.
You said proposed decision.
Okay, sorry. Okay, yeah, sorry. So it also addresses a side agreement in federal court for attorney's fees, but frankly, that's beyond the four corners of our settlement document here. That's something that takes place in the federal court. Again, the original 2014 decision included funding for a GHG research program that didn't originate from the 2014 settlement parties. It was proposed by the Senate Commissioner and was accepted by the parties. Fast forward to the 2018 agreement, recent filings from the parties in the 2018 agreement show that the current settling parties don't have a meeting of the minds as to the source of the funding of the proposed Cal State funds. I also have to point out that since then, California has spent many millions of dollars on other GHG research initiatives, including the EPIC program administered by the Energy Commission, which focused on GHG emissions to replace the San Onofre nuclear generating station. An additional standalone program that wasn't subject to the kind of scrutiny and competitive nature that the CEC's EPIC program proposed is probably just doesn't take advantage of targeting that you get from that kind of effort. So when we reevaluate the 2014 program with this information in hand, we just find that it's not in the public's interest to support this standalone GHG research program as part of the San Onofre settlement, even if it's funded by shareholders. That may be appropriate for shareholders, but I don't think for us to pass. So we sought a modification of the proposed settlement to strike the provisions which provide for this GHG research. Otherwise, aside from the inclusion of this federal settlement, which is not really part of our business and raises other issues, and the questions that I've raised about the GHG research program, we find that the proposed settlement is sound. So I just want to say that the side federal court agreement depends on the outcome of this multi-party regulatory investigation, and in that way the federal court agreement sort of inserts it herself into the CPUC proceeding. And here's a couple of central issues from my perspective. And it's not just related to this specific decision, right? It's a pattern that I've seen elsewhere. I talk about the detrimental effects of side agreements that are delivered in settlements or in CPUC proceedings. In a cost of capital proceeding, I have my frustration with the use of undisclosed side agreements and settlements on that case at the Commission. It also became an issue in the plan, not a settlement, but still a document filed before us for our approval in the Diablo Canyon case. Settlements are often a compromise between ratepayer advocates, utilities, and numerous parties. And we have to be presented all the material elements of these kinds of agreements in order to really understand whether they're part of our business, whether they're appropriate. So whether these site inducements can be characterized as part of the settlement, or an inducement, or a lagniappe, or as has happened elsewhere, as an extortion or bribe, it just really, it compromises our processes. Furthermore, the scale of this particular settlement, I worry, extends this practice into our intervener compensation program. And in this, entering this federal court settlement in as part of our process and asking us to address it, then presents a precedent whereby other parties who are unsatisfied with our scrupulous review and intervener comp, they just turn to the courts as being a vehicle to get more money out of ratepayers than they would otherwise get in intervener comp. So I fear that by actually acceding to this as part of our proceeding, we open that door. So again, I don't find that it's technically a violation of our rules, but I don't think it's consistent with the spirits of the rules. We don't approve the side agreement of the proposed decision. The proposed decision is not the way to test the side agreement for the court. I think that we should address the issue of side agreements in future commission rules. So again, while I disagree with the use of side agreements, I reviewed the parties' proposed 2018 settlement, found to be in the public interest to be modified as described in the ALJ's proposed decision. Per the terms of the proposed decision, the parties have 10 days to file and serve on the service list of the proceeding a notice accepting the proposed modification to the settlement agreements, eliminates the GHG program's reference in the 2018 and 2014 settlement agreement. The settlement agreement becomes effective on filing such a notice. If they don't file such a notice accepting the modification, then the administrative law judge is directed to issue a rule scheduling evidentiary. That would then give us a different forum in which to examine these issues. So given the benefits for ratepayers and shareholders from the adoption of the settlement agreement as modified, I encourage party to accept the modified settlement. I want to thank ALJ Darcy Howe for her hard work and endless hours. I want to thank the legal division and also James Ralph, who's working on my staff. And I give all of my gratitude to Eric Green for his many years of work on this and his examination. So with that, I turn to the commissioners for comment.
Thank you, President Picker, and thank you for this work on this proceeding. Our office BK'd with President Picker on this, and I know Judge Hauk and his office put in a lot of work along with Eric Green on this proceeding. And I also want to thank former Commissioner Sandoval, who also put a lot of work on this proceeding. So I will support the proposed decision. I think your concerns about side agreements are well taken, and we will, in the Policy and Governance Committee, Commissioner Rechthofen and I are going to be teeing that issue up. As you mentioned, one aspect is whether or not the side agreements are disclosed, but then also how would the Commission evaluate them in the context of examining a settlement and whether or not the settlement is in the public interest. So the committee will be holding a workshop on August 30th, and that is one of the agenda items on the workshop. And so I'm looking forward to having a robust and public discussion about how we should handle these agreements going forward. So I thank you again and appreciate the hard work that went into this, both on our end and also the settling parties' work to resolve this issue. Thank you.
Thank you, President Picker. Thank you, Judge Houck and staff, for all of your work on the proceeding. I, too, will be supporting this item. Ratepayers deserve closure on this issue, so I'm glad to see the proposed decision come forward. In short, I do find the proposed decision well-reasoned and balanced, and therefore will be supporting it. I also want to agree with President Picker's comments and concerns regarding the side agreements and the interaction with our intervenor compensation program, and just the overall need to ensure the integrity of the settlement process. So I look forward to supporting the work that Commissioners Randolph and Rechtschaffen will be doing on this matter. Thank you.
Thank you, and I also want to start by thanking Neil J. Houck and all of the staff, Eric and legal division, and spending a lot of time with us going through all the details and making this decision pretty clear from my perspective that it is a fair settlement for ratepayers. I think it's a very clear benefit from the previous settlement, and in having the benefit of having the nuclear decommissioning proceedings, the cost share that was reached seems very appropriate. I also have strong support for what the President was stating on side agreements, in particular with the agreement that was put forward involving the federal court agreement. And obviously we have no role in reviewing or approving that proposal. And I want to restate what was in the proposed decision, that we are not waiving or conceding any right that we have in that federal action. I do have a slightly different perspective on settlement agreements involving things that are more clearly in the public interest, and I do look forward to engaging with Commissioner Randolph and Rechtschaffen's efforts in trying to figure out when and if and when these are appropriate. I think that in previous settlements that I have seen, there have been some that have merit. But I do believe that in this instance, it is inappropriate, and we have very little information on the details of those side agreements. So again, I want to thank the President and Judge Houck for all their work on this.
I share my colleagues' sentiments. I'm supporting the decision. I'm concerned about the attorney's fees agreement. I'm concerned that the fees are not warranted, and as the decision said, it raises concerns about using the federal court process to bypass our regulatory process and to bypass our intervenor comp process. And as Commissioner Guzman-Aceves says, we do reserve the right to raise these concerns in the federal court litigation.
Okay, clerk, please call the roll.
Good morning, Commissioner. Commissioner Guzman-Aceves.
Aye.
Commissioner Peterman.
Aye.
Commissioner Randolph.
Aye.
Commissioner Rechtschaffen.
Yes.
President Picker.
Yes. Item 24 is adopted. Thank you. So we move on to item 25, I believe.